judgment would be the subclassification of a scheduled caste, which really was the case which all the states were involved in. We need to organize our court systems better. We must be ready for a digital era. We must use digital tools. We must use technology. So let's start with the hits for a moment. I think the biggest hit was from 24 onwards, the Supreme Court has been talking about liberty consistently and has been liberty oriented. I think that's been one of the hit. There are notable judgments of the former Chief Justice Gavai, Justice Urikhan, there are judgments of Justice Abhiyok, or Justice Nath. So all these judgments are liberty oriented, and I think that's been one of the important things. The second important judgment would be the subclassification of a scheduled caste, which really was the case which all the states were involved in. The court has upheld the fact that subclassification is possible because if you're going to try and improve the social order, you have to try and ensure that the benefit reaches the concerned class within the class. And that, I think, was the second most important thing. The third one, according to me, is the governor's judgment, where the court has, there was a view taken by Justice Pardiwala that it came to the larger bench. The larger bench has said it is not that the governor's inaction is untouchable. There is limited judicial review, but on a case-by-case basis, we can exercise judicial review and ensure that governance is not affected. I think all of these are three very important decisions. On the misses, I would say, is this. I think one of the problems we are having across the board is we are not filling our positions for judges. The high courts don't have enough judges. The Supreme Court, we do manage to do it. The trial courts also have a dearth of judges. That's an issue which needs serious reflection and action. We can't just have a situation where first we go through a process of names, we select the names, then we shortlist the names, then those names go from one process to the other. And by the time they reach, time may have elapsed of as much as a year or 2 years. And then there are delays both through the collegium systems and also through the government. And these delays are ensuring that we are working at sub-strength. So who's affected? The consumer of justice. So I think that's a very big miss which we've been having, and that miss needs redressal and needs redressal fast. There is also this issue of moving judges from one court to the other, which according to me is a welcome thing, because sometimes you need to have a change and new fresh approaches. After all, we do send chief justices from one court to the other. But that's one part of the picture. But what about appointing people who are waiting in the lines? And especially if you don't appoint people who are taking promotion from the trial court, whether a magistrate, people who come up from the ranks as magistrate or from the sessions ranks, the point is you're letting people who have worked hard for their careers, you let them lose out. And then when you do appoint them, you give them very short tenures, which makes them feel disillusioned in a sense. So these are issues which we need to really seriously address. That's the first issue in terms of the very big miss, I would say. The second miss is our courts are polyvocal courts. That's to say, the courts have different benches. Today I find it's not just in the Supreme Court, but even in the High Court level, judges are often judges of a two-judge bench strength or a single judge in the High Courts are overruling or in effect distinguishing but overruling judgments of coordinate benches. That's something which is not the principle of contrary to the principle of stare decisis, which is to say that there is a set out norm. Either you accept the judgment of a coordinate bench, the older judgment must be accepted. If you are disagreeing with it, refer it to a larger bench. There's a recent decision where Justice Pardiwala has dealt with it last year and said, look, there has to be consistency. So I think this is a very important aspect which needs to be dealt with. Consistency, because when you have two judges taking different views and one not considering the view of the other or overruling effectively the view of the other, what is happening? What is really happening is that is causing confusion in the minds at the High Court level as also at the trial court level, and that leads to inconsistency. The whole point of judicial decision making is that there should be consistency, that the consumer of justice, the lawyer for either side, is aware as to what in a given fact situation or a given legal interpretation should be the answer to the case that he or she is putting forth. If you don't, then lawyers will keep experimenting. Litigants will be encouraged to experiment, and therefore the docket burden is going to increase. So I think consistency in judicial decision making is the second most important thing. The third thing is the consumer of justice wants fast, expeditious justice. If we can't have fast, expeditious justice, if the backlog of COVID era is still plaguing us, then are we being fair? I must tell you, I see judges working very hard, lawyers working very hard, people work. I see judges sitting till 6 o'clock and actually disposing on matters in the High Court, sometimes even sitting late in the Supreme Court, 4:35. The point is, trial court judges are sitting beyond hours. Everybody's sitting beyond hours at times. But the issue is we are still not being able to deliver fast justice. And if we don't deliver fast justice, then the consumer of the justice system is going to get disillusioned with this temple of justice. So these are the three concerns that I have. Call them misses, call them concerns, but these are the broad concerns that I believe need to be addressed. And I'm hopeful that in the year to come, not the years to come, not only the Chief Justice of the Supreme Court, but the Chief Justice of the High Court and the Department of Justice will join hands to try and find a solution to satisfy and benefit the consumer of justice, the ordinary litigant. Major milestones, if we address the three misses, if we can achieve a rate of 90% strength, 90 to 95% strength, 90% of strength of all our courts, from the trial court to the High Court to Supreme Court, I think that's a major milestone. That will be a game changer completely. Secondly, the judiciary is sometimes called into question because, these days people say impeachment is a very cumbersome process. What is happening? So I think one of the things is perhaps it's time for us. There is an in-house procedure which is created by virtue of judicial interpretation where the Supreme Court can order an inquiry and carry out that inquiry into the conduct of what is considered, what is errant behavior on the part of a judge, but not up till which is not that it may or may not constitute cause for impeachment. I think that must be part of the constitutional framework. That needs to be now have constitutional acceptance. There should be an amendment legitimizing this and giving it constitutional power. That will be, I think, one very big game changer, at least for the constitutional courts. Because while we have powers, there are disciplinary action that can be taken and action of suspension, termination, inquiries can be done into trial courts. That does not exist for the High Court or the Supreme Court, which are constitutional courts. And the purpose behind that was to protect them. Now, once we have an inquiry, in-house inquiry procedure through judicial interpretation, I don't see any reason why it should not be given constitutional acceptance. The third thing which we need to address is we need to organize our court systems better. I think a lot of time that is happening in our court systems, a lot of time there are delays, systemic delays which are entering, and for that we will have to join together. I would believe that a lot of the rules of the various high courts are archaic. In some cases, there is the Indian Criminal Law Guidelines case in 2020 or 21, where the Supreme Court came out. Justice Bobde was then the presiding judge in that matter, later was Chief Justice. He was the one who came out and laid down certain guidelines to smoothen the course of criminal justice. Yet, there are divergent voices on that. So, these kind of actions which are now being pushed as reform of the justice system through judicial diktat or judicial intervention needs to be done at a systemic level, and the high courts must be proactive in upgrading their rules, in ensuring that the processes of justice are not lingering in the decades that have passed. We must be ready for a digital era. We must use digital tools. We must use technology. We must ensure that matters which are, in a sense, mechanical, let's say accident cases or reports where untraced reports, which is already been done in part, all such matters are dealt with to reduce the bulk of the system. We must also consider, and the legislature must consider, is it not time that matrimonial offences, cruelty to women, important offence, but is it not time that should be seen as a civil wrong, make a fast, expeditious remedy for it, but why invoke the criminal process? 138 check bouncing, it's clogging up the court system. Is it not time to make sure that RTGS becomes mandatory or direct bank debits become mandatory and take the checks out of the system? It would reduce the burden on the courts. These are the kind of innovations we have to look at, because we have to see which are the numbers that are clogging up the courts. Plea bargaining, for example. We have never looked at plea bargaining seriously. Plea bargaining is only available for offences up to 7 years. It's hardly utilized. And that too because you're going to get a custodial sentence. So who will go for plea bargaining? What is the incentive in a court to go for plea bargaining? What is the incentive? Why is it that courts are not giving probation? These are questions that need to be asked. These are questions that need to be answered. We need to debulk our justice systems. We have tried. On the civil side, I must tell you, we brought in arbitration. We brought in the Commercial Courts Act. The point is, it's important to give commercial courts because we are an emerging economy. We have to have strong commercial court system. But at the same time, what about the litigant who's outside the commercial court system, who is just a civil claim, a property dispute, or a rent dispute? Should that consumer of justice not have a fast, expeditious decision and a consistent decision? So these are the areas which I believe across the board. A person who has a grievance with the government on service law, a question that needs to be really asked is, government is the largest litigator, whether it be state government or center. Should every issue be challenged? Should every claim be put in court? Should every case come however late with a 50-day or 100-day or 2,000-day delay? Should every case be brought to court? There are areas for introspection in judicial governance and within the government itself. All of these need to be addressed. That's my wish list for this year.